prospect of facing an employment tribunal claim can be a daunting one for employers. Here are a few tips on how to manage the process. Work out a game plan as soon as possible. To do this, an employer needs to understand the strength of its defence, the potential compensation that could be payable if they lose, and the amount of legal costs they could face. Bearing in mind, legal costs are not usually recoverable even if you win. If you're thinking about settlement, it's important to consider the potential impact on other employees who may bring claims in the future if they think they'll get a quick payoff. That said, fighting a case where the defence is weak is rarely to be recommended. An employer always has to take account of commercial considerations, such as the time commitments, the impacts on those involved, and whether settlement can be achieved at an acceptable level. Preparation and teamwork with your client are both key to success at tribunal. The more time you invest in the process, the more likely you are to get a good outcome. As a lawyer, it's really important to understand your client's business and be able to fully explain the context in which events are taking place. Where a case is obviously misconceived, a case can be struck out. Also, where a case is weak, a tribunal can be persuaded to order the claimant to pay some money into the tribunal if they want to pursue that claim to a hearing. The best way to avoid tribunals is to have robust, up-to-date contracts, policies and procedures which clearly set out the expectations on both the employer and the employees. Training of HR and line management is also crucial. It's not just about having the right paperwork, it's also about how policies are implemented and how HR processes are dealt with in practice.